In relevant part, they argued that the MSA does not authorize NIMFs to mandate that they pay for observers required by a fishery management plan. The district court granted summary judgment to the government. I believe when you say summary judgment, I think that's a pretrial dismissal of the of one of the side's claims, and you just say the other side wins. I think that's what it means. What is summary judgment? Summary judgment is a judgment entered by a court for one party and against another party without a full trial. Okay, so you could do like a motion to dismiss would be for some reason you think that the case against you is without merit. So you could, and then the court could grant your motion to dismiss, meaning they would dismiss. I believe it's either with prejudice or without prejudice. I think without prejudice means that the other side can refile. With prejudice, I think means you cannot file this case again. Or you could file a motion for a summary judgment. I think that if you file a motion for a summary judgment, I think the idea is basically saying, like here are the facts as laid out. Like the other side doesn't even really disagree with these facts. They're just going to make some autistic argument. Like, can you just grant this? It's a waste of all of our time. And the court might say, okay, motion for summary judgment granted. You're right. The other side is retarded. You win. And then they don't even bother going to court. These would be, I think, wait, somebody said motions for summary judgment happen after discovery. Motion to dismiss is just done on the pleadings. Oh. Motion for, is that true? I guess there's a whole different, if you wanted to learn about all of the phases of a trial, what class would this be in law school? Would this be would this be civil procedure, or it'd be nice to just know all of the sections of this. In civil cases, either party may make a pretrial motion for summary judgment. Does pretrial necessarily mean before discovery, or could pretrial still be after discovery? Well, discovery is pretrial still, right? Wait, no, there is a motion for judgment on the pleadings. That chatter is wrong. Oh. Under Rule 56 of the Federal Rules of Civil Procedure governs summary judgment for federal courts. Under Rule 56, in order to succeed in a motion for summary judgment, a movant, meaning the person who filed the motion, I believe, must show that 1, there is no genuine dispute as to any material fact, and 2, that the movant is entitled to judgment as a matter of law. Material fact refers to any facts that could allow a fact finder to decide against the movant. Okay. Many states have similar pretrial motions. Wait, then this wouldn't have to be after discovery. So I think that it would be I'll try to guess here. I guess we have some lawyers in chat. So my guess would be something like, let's say that you file, let's say that you're taking somebody to court because they didn't pay rent. Okay, so you're in civil court because it's not a criminal matter. So you file a case against somebody. You say, hey, this person owes me $5,000 in past due rent. Okay, and they file that complaint to the court. Let's say that the other person, you always typically try to file to dismiss or whatever. But let's say that the defendant, how would you say you accept the motion? Or I guess, so would it be the plaintiff would file a motion for summary judgment, and the plaintiff would say, me and the defendant agree that he didn't pay anything, and that he was supposed to pay me anything. And then I guess it would be on the defendant to file a counter motion against summary judgment saying, well, actually, here are some legal reasons why I didn't pay. So maybe would it be a motion against summary judgment? Is that what you would file? You'd file something and you would say something like, hey, the reason why I didn't pay rent is because you violated this contract as part of the blah, blah, blah. And then the court would look at it and then they would go, okay, well, this would be a legitimate reason not to pay rent. So now we have to do a fact finding or a factual dispute in court or whatever, blah, blah, blah. But if you filed a counter motion and you said something like, oh, well, I didn't actually pay this because I was actually feeling really depressed in these days and I just didn't feel like paying my rent, so fuck you, then the court might look at that counter motion or whatever and they might say okay, well, that's not a legitimate reason not to pay it. You seem to not be disputing any of the facts that the plaintiff is putting forth, so we're going to grant summary judgment for the plaintiff because you both agree on the facts of the case, and if the facts are correct, there is no dispute that would lead to a different outcome, so we're just going to grant judgment for the plaintiff, I believe. What do you call it when you file a motion against something? Most parties will also file a counter motion for summary judgment at the same time. Counter motion for summary judgment. Does that mean that you're filing for your own summary judgment, or does that mean that you're filing against their summary judgment? They can respond to the motion with a motion in opposition, but if they are filing that motion, then the defendant filed an answer admitting to the complaint's proceedings. If they are filing that motion, then the defendant filed an answer admitting to the complaint's proceedings. Oh, so once the initial complaint is made to the court, that means that there's already been service. That means that there's already been service given to the defendant, and they're already made aware of the complaint against them. And then what do they file? Fuck, we should just do. This is supposed to be the most cancerous course at law school, or I've been told by legal people or by law school students. I don't know if that's true or not. Civil procedure is supposed to be AIDS. I don't know why I just Googled civil procedure like I was just gonna find my fucking answer. I bet there's a YouTube video on this. Fuck, hold on. Right, otherwise they'd file for a default judgment if no answer is filed. Okay. The 5-minute legal master series. 5-minute I can be a legal master in 5 minutes? Hell yeah.
Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights attorney Nicholas D. Crowley discusses motion for summary judgment.
Motions for summary judgment are probably not very well understood by a lot of plaintiffs in litigation. Obviously, a suit has been filed and the defendant has filed an answer raising some factual issues.
Okay, a suit has been filed, meaning that a plaintiff has filed a complaint with a civil court alleging that there's been some breach of some civil things, like a contract, okay? So the initial complaint is filed, and then...
A suit has been filed and the defendant has filed an answer raising some factual issues.
Okay. Now, assuming that the person filing the complaint is not fucking retarded, that complaint probably necessitates some type of relief that they're seeking, right? You broke this law, or not you broke a law, I'm sorry. You violated some civil thing like a contract, therefore I am entitled to receive this type of relief from you, right? So we agreed that you would pay rent, you didn't, I want this rent. And then ideally, the defendant is going to file something back claiming that some fact is wrong. Otherwise, you would just you'd be like, oh, okay, yeah, right. So I'm guessing your counterfiling has to contest with some factual matter that the plaintiff has filed.
Obviously, a suit has been filed and the defendant has filed an answer raising some factual issues. I have many clients come to me and tell me, well, these allegations, they're simply false. That's not what happened. We have a number of witnesses that can refute everything this defendant is saying in his answer. Can't we move for summary judgment on this? Because this is simply just wrong.
Ooh. So a judge pre-trial, right? I think he'll say, right? A judge pre-trial can't rule on the facts. I don't believe that a judge is allowed to pick which fact is right or wrong. That is what a jury is for. Or a judge can do it after a trial if you don't have a jury trial. Summary judgment, we'll see. Okay, predictions. I think summary judgment can only happen if there is no contesting on any of the facts that are material to the complaint alleged or the relief that they're seeking. You might contest some facts, but they're not relevant. So like maybe the guy will say like, oh, well, actually, my client, who is a hippie fuck, didn't pay his rent, and the guy might respond and say, I might not have paid it, but I'm not a hippie. I'm actually a Scientologist or something, right? So it just doesn't. It wouldn't matter. It's okay. You might contest it back. But pre-trial, I don't believe judges are supposed to determine which facts are true or not true. That's what the trial is for. And then the jury or the judge evaluating after, I think.
My short answer to that question is no. False statements, or perhaps more accurately, inaccurate statements, or the ability of the plaintiff to produce witnesses to rebut those statements do not give rise to a basis for an immediate motion for summary judgment. You've got to think about the standard for summary judgment. A motion for summary judgment is a legal so what, meaning even if everything the opposing party claims is true, so what? Even admitting the facts stated by the opposing party, we are still entitled to summary judgment as a matter of law for the relief that we have requested, because there are no real genuine issues as to any material fact, and we are entitled to judgment as a matter of law. Now, the example I gave at the outset of this discussion, inaccurate allegations made by the defendant, witnesses being available to refute, that's a determination as a matter of fact, which requires a trial.
Yeah.
Hopefully, in a trial, the trier of fact, whether that trier of fact is a judge alone or a jury, believes your witnesses and disbelieves the defendant or the defendant's witnesses. But a motion for summary judgment is a determination by the judge as a matter of law that you're entitled to the relief you requested without the need of going through the time or the expense of a trial. Now,
when somebody says, so in legal speak, when they talk about like a matter of fact, they're referring to like material facts contextually, like of the case. So for instance, if somebody says like, you are supposed to pay me because that's like what contract law, whatever says, that's not a matter of fact. That's just what the law is. Matters of fact would be things like, well, did you actually pay him? This guy says he did. This guy says he didn't. Did you owe him this money? Well, in the contract, like I didn't actually sign this or whatever. These are like disagreements of like material fact. But that's different than just like the law of what the law says should happen. Those aren't facts. That's just like, I think you would just call that the law, right?
The need of going through the time or the expense of a trial. Now, how is a basis for summary judgment determined? Well, the first thing the attorney should look at, and you should look at when the attorney reports to you about the answer that is filed to the lawsuit, is what admissions have been made by the defendant in the answer that was filed. These admissions, where the defendant responds to your claims, they establish facts that are not in dispute. Secondly, you have to take a look at the defendant's affirmative defenses that are being alleged, and is there a need to refute them as a matter of law? Third, and probably most important from a summary judgment standpoint, is you're going to have to engage in pretrial discovery, which is another topic that's in one of our legal...
Oh, damn. Multiple discoveries? There's pretrial discovery? How many discoveries are there?
...master presentations. You can make effective use of written discovery, such as requests for admissions, to have the defendant admit to the truth of certain facts. If the defendant denies certain facts, you can follow that up with interrogatories and say, if you denied that request for admission, tell us what you claim the facts to be.
Are requests for admission done under like penalty of perjury at that point? What happens if you lie? If you lie pre-trial, request for admission. The defendant lied when we issued request for admission. Okay, so these are done under oath. Can we compel him to say the truth via motion to compel further responses, or can we confront the attorney? All right. If got your answer, you just don't like it, so compelling the responding party to answer further won't help. A lawyer would be pleased that someone lied under oath in a discovery process or discovery response, assuming you've got a collateral way to prove the truth. That you can cross-examine them, impeach them, and rebut them in later proceedings. They will have no credibility about anything if this lie is material to the litigation. If you don't know how to capitalize on this, hire counsel to help. Okay. I think it's the case that I think everything that is done in the court or through the court process, I think you're attesting to all of that, I believe, under oath, right? Things that you believe to be true. You might not be right, but I believe that there are things that you believe to be true. So if you are filing motions, if you are filing complaints, anything that you say during like a deposition is all under oath. Like you can't just lie in some of these because you haven't like gone before a jury yet and you're not sitting somewhere. Actually, I think even for a deposition, I think they make you like swear. They'll make you do like an oath pledge, I think, even before a deposition. But I think even before that, I think in all of your motions, I think those are all supposed to be true. You're supposed to be attesting things that are true. That seems self-evident, right? You can't just fucking lie to a court, right?
Perhaps most effective in trying to set a matter up for a motion for summary judgment is to take the deposition of the defendant and grill the defendant, question the defendant intensely about the defenses that he's asserting or the allegations that he's made in the counterclaim. And hope.
Why not take the bar exam and start your own practice? First of all, if I were to go to law school, first I would think I would have to go back to undergrad for a full 4 years. I don't think any of my old credits are good anymore from UNO. Then we would have to go to law school, which is another 3 years, assuming I make it through undergrad in 4 years. And then after 7 years, fuck that. Then we'll be bored. We'll be playing Factorio again.
Through that testimony, establish that there really is no factual dispute. Once you establish there's no factual dispute based on the written discovery and the admissions you've been able to obtain, only then can a motion for summary judgment be sought. Now, you can move for summary judgment, obviously, for the claim that is set forth in your complaint. You can move for summary judgment as to the defendant's counterclaim. If the defendant has determined that he's going to try to file a counterclaim to try to get some leverage against you. File a motion for summary judgment as to both, but keep in mind a key thing, that if the defendant filed a counterclaim as a means of trying to intimidate you or leverage a mutual dismissal out of you, and you're able to get summary judgment dismissing his counterclaim, he's lost a lot of leverage. All right? The other thing that you can use the summary judgment process for is to limit the issues for trial. Sometimes summary judgment may not be...
So you can get partial summary judgment. So I think what he's saying is, like, when you file a complaint, oftentimes the defendant will file a counter complaint, because why the fuck not? If you're going to sue me, I'll sue you too. Fuck it. However, one thing you might be able to do is, in the process of pretrial discovery, where you're taking depositions from each other, you might be able to get enough out of him to say, well, before we go to court for my complaint, I'm actually going to file a motion for summary judgment of the counter complaint. So then when you guys do end up going to court, now their counterclaim isn't even live in court. It's basically you can kill it before. Although I don't know what the difference would be. I don't know what the difference would be between, like, a motion for summary judgment versus, like, a motion to dismiss. I don't know what the difference between those two things are. I guess we could Google it. Right. Motion for summary judgment versus motion to dismiss. I guess for summary judgment you want something, but why wouldn't you just file a motion to dismiss the counterclaim? Why would you do a summary judgment on their claim? Can you really get a judgment on their claim? A Florida motion for summary judgment is a request for the court to rule in favor of the moving party on one or more claims of a case of matter of law. While the defendant always files a motion to dismiss, a motion for summary judgment may be filed by either the plaintiff or the defendant. While a defendant always files a motion to dismiss, a motion for summary judgment always files a motion to dismiss. Oh, can a plaintiff not file a motion to dismiss from a counterclaim? One is a judgment, one is a dismissal. I'm just waiting for Leon's Law to type the answer. It doesn't say they can, but they consider a plaintiff on their counterclaim. But they're considered a plaintiff on their counterclaim. Huh, okay.
Is to limit the issues for trial. Sometimes summary judgment may not be rendered for all the relief that you have requested. That's often referred to as a partial summary judgment. Perhaps you may be able to have obtained summary judgment as to liability, and the trial is limited only to the amount of damages. Or the judge can enter an order setting forth the facts which are no longer genuinely disputed as a result of the admissions in the answer and the information developed through discovery. But summary judgment, as you can see, is not an easy process. All the opposing party has to do is show that there's a genuine issue of fact for trial, and you can try to overcome that through appropriate use of discovery, whether it's written or depositions. Thank you very much.
Wow. Thank you. Okay. Petitioners, Loper Bright Enterprises, Inc., blah, 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 and blah, 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 are family businesses that operate in the Atlantic herring fishery. In February 2020, they challenged the rule under the MSA, which incorporates the Administrative Procedures Act. In relevant part, they argued that the MSA does not authorize NIMFs to mandate that they pay for observers required by a fishery management plan. The district court granted summary judgment to the government. It concluded that the MSA authorized the rule, but noted that even if these petitioners' arguments were enough to raise an ambiguity in the statutory text, deference to the agency's interpretation would be warranted under Chevron. So what happened was, I'm curious how these, like, random fishery people, it must be people who study like federal rules and study legislation that want to make an example, or not make an example. I shouldn't say that. That's a very negative thing. But people with an interest in like this type of stuff must find parties to go and to do these lawsuits, because there's no way that like a random fishery, right, would be like, wait a second, are you guys really authorized to regulate this? I'm familiar with the Supreme Court case, and I don't think your federal rules are actually authorized explicitly by the legislature, right? It must be like people that find, yeah. Not that there's anything wrong or bad about that, by the way. The ACLU finds cases. It's okay to find cases like that you want to like trial for whatever. Like that's a totally legitimate way of challenging certain things. Okay, so what happened was when the case was filed, the government was granted summary judgment, meaning that there wasn't a disagreement on facts between both parties, and the government won their case before any trial. And then part of what the district court said, so district court is going to be your first stage federal court, right? District, then your circuit court, which is your court of appeals, and then Supreme Court, right? So the district court granted summary judgment to the government, and then the district court said that the MSA authorized that rule, but even if your argument was that the statutory text didn't actually give them the right to have this rule, we would give deference to the agency because of this prior holding, this prior opinion that was written under the Chevron case in I want to say 1948. It's not 1948. 1968, I think, right? Okay. A divided panel on the D.C. Circuit affirmed meaning they held the decision of the lower district court. Okay. The majority addressed various provisions of the MSA and concluded that it was wholly unambiguous whether NIMS may require Atlantic herring fishermen to pay for observers. Because there remained some question as to Congress's intent, the court proceeded to Chevron's second step and deferred to the agency's interpretation as a reasonable construction of the MSA. So this means that, remember, Roberts is saying that the Chevron case laid out a two-step process. First, when somebody challenges a federal rule or the way that an agency is acting, they check to see, well, did Congress explicitly authorize it? So the court said, no, they didn't. But then secondly, they looked at the executive agency and they were like, okay, well, if we interpret Congress's order, the legislation passed, is this like probably legit? And I was like, yeah, probably is. It's probably okay, right? As per Chevron, this two-step analysis came from Chevron, okay? So the court proceeded to Chevron's second step and deferred to the agency's interpretation as a reasonable construction of the MSA. In dissent, Judge Walker concluded that Congress's silence on industry-funded observers for the Atlantic herring fishery, coupled with the express provision for such observers in other fisheries and on foreign vessels, unambiguously indicated that NIMS lacked the authority to require fishermen to pay the wages of at-sea monitors. That was the dissent. Okay. Petitioners, Relentless Inc., Huntress Inc., and Sea Freeze Fleet LLC own two vessels that operate in the Atlantic herring fishery, the FV Relentless and the FV Persistence. These vessels use small mesh bottom trawl gear and can freeze fish at sea so they can catch more species of fish and take longer trips than other vessels. Okay. For any land lubbers, FV is simply the designation for a fishing vessel. Is land lubber, is that like a meme word for land lover, or is that like an actual word? It's Roberts giving us a little meme here, or I can't hear lyrics. It's fucking my mind up. Land lubber, a person unfamiliar with the sea or sailing.
Landlubber.
Okay. Nice. Somebody said, wait, fuck. Somebody said, I have no idea how risky the impact it will have in other areas of law. Wait, is it before? As an immigration attorney, I'm ambivalent about this case. I'll be able to sue the DHS more, but I'm not a fan of the regional inconsistencies there will be now. Okay, well, fuck. Well, now you don't need me to tell you, but yeah, obviously, assuming what this case's ruling is what we've heard and read about, is a whole bunch of federal agencies are now going to be open towards people challenging the federal statutes that are in play. And there might be some federal statutes that now get overruled and they fall to the wayside because, whatever, I don't know what test they have here, but basically they are going to say that they're not authorized to have these federal regulations. To understand Chevron, you need to understand Mead and Skidmore, then read FDA versus Williamson Tobacco, and finally West VA versus EPA. Okay, I'm good. And take longer trips than other vessels, about 10 to 14 days, as opposed to the more typical 2 to 4 days. As a result, they generally declare into multiple fisheries per trip so they can catch whatever the ocean offers up. If the vessels declare into the Atlantic herring fishery for a particular trip, they must carry an observer for that trip if NIMS selects the trip for coverage, even if they end up harvesting fewer herring than other vessels, or no herring at all. Wait, hold on. I don't know what that comment supposed to mean. This is another opportunity for lobbying to make the rules for things not specifically written into legislation. I don't know if you're saying that that was before or after, but technically this would be, if you don't like lobbyists writing like weird federal regulations or whatever, technically this would benefit you because now it has to be explicitly written by Congress first, right? Okay. This set of petitioners, like those in the D.C. Circuit case, filed a suit challenging the rule as unauthorized by the MSA. The district court, like the D.C. Circuit, deferred to NIMS' contrary interpretation under Chevron, and thus granted summary judgment to the government. The First Circuit affirmed it relied on a default norm that regulated entities must bear compliance costs, as well as the MSA sanctions provision. And it rejected petitioners' argument that the express statutory authorization of 3 industry funding programs demonstrated that NIMS lacked the broad implicit authority it asserted to impose such a program for the Atlantic herring fishery. The court ultimately concluded that the agency's interpretation of its authority to require at-sea monitors who are paid for by owners of regulated vessels does not exceed the bounds of the permissible. In reaching that conclusion, the First Circuit stated that it was applying Chevron's 2-step framework, but it did not explain which aspects of its analysis were relevant to which of Chevron's 2 steps. Similarly, it declined to decide whether the result was a product of Chevron's Step 1 or Step 2. We granted certiorari in both cases, limited to the question whether Chevron should be overruled or clarified. Article 3 of the Constitution assigns to the federal judiciary the responsibility and power to adjudicate cases and controversies, concrete disputes with consequences for the parties involved. Hold on, it's too loud for me. That's the problem. Nobody is lobbying random OSHA bureaucrats. Congress, on the other hand, ... I mean, well, people would say everybody gets lobbied, right? So, although theoretically it should be impossible to lobby a federal bureaucrat, right? Right, because they don't run for office, so how can you lobby them? In your current understanding, how will this affect the ATF's enforcement and reinterpreting of SBR regulations? Good question. My total layman's without reading any of the federal statutes about firearm regulation, my guess would be, would there be a whole bunch of federal regulations that could now theoretically be challenged. That a whole bunch of these things could be like, wait, hold on. This particular act from Congress doesn't authorize the ATF or, to regulate firearms in this way. This all has to go. That's possible. That'd be my guess. But I don't know how explicit the statutes are, so I can't say without reading them, right? This drives me nuts. Destiny is Jordan Peterson when it comes to law. He doesn't even know how to brief a case, but is going full steam ahead as though his extraneous expertise is sufficient. What? Anti-alias, what have I said so far for any of this? I don't even think I've given an opinion on anything yet. I'm just Googling things to make sure I understand the civil procedure motions, and then we're just reading what Roberts is saying, and then just like interpreting it and making it understandable. We haven't even got to a point where I'm like entering an opinion on anything yet. What have I said wrong? Also, I really like the, was it on I don't know if it was on my YouTube video or if it was on Ben Shapiro's video. No, Ben Shapiro didn't make a video with me. It was on my video where people go from, so first there was a Wikipedia warrior.
Let's take this to...
But so now, okay, well, fine. Well, let's read entire Supreme Court cases and then other stuff and figure it out. And now it's, well, Destiny's not a lawyer, so he can't read this anyway. Like, wait, what the fuck? If I were to go to like law school and get it and become a lawyer, would it be what? Destiny hasn't passed the bar? And then if I passed the bar, would it be, well, Destiny's not even practicing? Or what law school did he go to? Like, Jesus fucking Christ. Jesus. Okay. Article 3 of the Constitution assigns to the federal judiciary the response. Also, in my layman's opinion, I feel like Supreme Court decisions are authored for the American public to read. These are published for the American public to read, and they write a lot of stuff that my guess is going to be an actual studied and learned constitutional lawyer or anybody that's been to law school doesn't need said, right? Like this sentence right here, Article 3 of the Constitution assigns to the federal judiciary the responsibilities and powers to adjudicate cases. Like if you went to law school, you know this. If you're a lawyer, you should know this, right? A lot of this is probably written literally for like a layman to at least be able to read the words and have a rough understanding of what's going on, right? Like, Jesus. People have polled he's not even practicing on Ricada before. Destiny, the comment that you didn't need to know the history in order to properly understand the case. The commenter brought up cases that a law student would be required to read before diving ... Okay. My guess is going to be how important an underlying case is probably going to depend. It's probably going to be on a case-by-case basis versus like whatever you're reading. So for instance, for the last Supreme Court opinion that we read about the immunity thing, having a good understanding of Fitzgerald, it probably is important. Like if I had the time, I would read through that entire case, right? Instead of the excerpts that I read from it. For this, I don't know if I need to know every single part of every single case prior to this to understand the two-step rule by Chevron, right? Unless I have like a huge disagreement or something that comes up here, maybe, then maybe it would be better to go back. But I don't think for every single Supreme Court case, you have to know every single case leading to every single case, all the way up to Marbury v. Madison. You have to go back, you have to do 20 cases is probably okay for the level of understanding that we're going for. I only have so much time throughout the day, right? I can't read every single fucking Supreme Court case that it relates to every single other fucking Supreme Court case. If I'm getting something incorrect, then point it out, okay? Actually, I'm sorry, hold on. I'm gonna rely so much more on this in the future, okay? If you are educated and there's something that somebody's missing, you should be able to point out that exact thing. If all you can say is, you haven't read enough or whatever, you don't know what you're talking about. That's what I would say. That's a heuristic that will serve you in 100% of life, okay? Okay. Jesus. The framer, okay. Article 3 of the Constitution assigns to the federal judiciary the responsibility and power to adjudicate cases and controversies, concrete disputes with consequences for the parties involved. The framers appreciated that the law's judges would necessarily apply in resolving those disputes. Would not always be clear. Cognizant of the limits of human language and foresight, they anticipated that all new laws, though penned with the greatest technical skill and passed on the fullest and most mature deliberation, would be more or less obscure and equivocal until their meaning was settled by a series of particular discussions and adjudications. Tessie didn't even read all the Federalist Paper number 37. The framers also envisioned that the final interpretation of the laws would be the proper and peculiar province of the courts. Unlike the political branches, the courts would by design exercise neither force nor will, but merely judgment. To ensure the steady, upright, and impartial administration of the laws, the framers structured the Constitution to allow judges to exercise that judgment independent of influence from the political branches. The footnote from earlier was... Fuck, I didn't even see where this footnote came at. Am I losing my mind? Footnote 2, where is it? Which paragraph? don't know why I'm looking at chat. Just tell me. You fuckers aren't reading. Both petitions also presented questions regarding the consistency of the rule with the MSA, see certiorari, and blah, 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 blah. We did not grant certiorari with respect to those questions and thus do not reach them. Okay. Oh, it was way up here. That's why I couldn't see it. Jesus, I thought I was losing my fucking mind. All right. This court embraced the framers' understanding of the judicial function early on. In the foundational decision of Marbury v. Madison, Chief Justice Marshall famously declared that it is emphatically the province and duty of the judicial department to say what the law is. And in the following decades, the court understood interpreting the laws in the last resort to be a solemn duty of the judiciary. When the meaning of a statute was at issue, the judicial role was to interpret the act of Congress in order to ascertain the rights of the parties. The court also recognized from the outset, though, that exercising independent judgment often included according due respect to executive branch interpretations of federal statutes. For example, in Edwards Lacey v. Darby, an 1827 court case, the court explained that in the construction of a doubtful and ambiguous law, the contemporaneous construction of those who were called upon to act under the law and were appointed to carry its provisions into effect is entitled to very great respect. Okay, so you can see the tension here that when the legislature passes a law, it goes to the executive for interpretation, right? Because the executive, well, hold on, I shouldn't use the word interpretation. If Congress passes a law and the law is ban all guns, and then all of a sudden a thing is created that is like a double-barreled gun that you pull a trigger like, you know, with your mind and it shoots bullets, like it might be up to the executive to figure out like, okay, well, did Congress, when they said ban all guns, does this include this thing as a gun, right? So the executive has to figure out how they can execute the laws passed by Congress in good faith. However, the judiciary might have some review of this as well because somebody might challenge Congress. Maybe some guy walks outside and he has a cum blaster. He can jerk off so hard and fast he can blast cum at people. And the executive is like, okay, well, your dick is illegal now because that clearly counts as a gun. He might challenge that law and it might go up through the courts. And now it's up for the Supreme Court to say, well, what was Congress intending with this law? And is the executive carrying it out in good faith, essentially? Like, what does this law actually mean? So even though the legislature is passing laws and the executive has to figure out how to enforce that law, it's also up to ultimately the court to determine like what the meaning of that law is so that all parties are treated fairly, basically, kind of, yeah. So there's like some tension? There's different checks at work here, I guess, yeah. Which is why they're saying the people who were appointed to the executive to carry its provisions into effect are entitled very great respect, right? The judiciary is not supposed to be the thing that's telling the executive how to carry out laws. That's the executive's job. The judiciary is only supposed to be there to interpret what's coming from the legislature, from Congress. Such respect was thought especially warranted when an executive branch interpretation was issued roughly contemporaneously with an enactment of the statute and remained consistent over time. That is because the long-standing practice of the government, like any other interpretive aid, can inform a court's determination of what the law is. So you know how people always say that like, oh, well, if we read the law, like you can tell exactly what it is, and we can find these clever loopholes and blah, 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 blah. Realistically, when laws are passed, there will be like remember when we did international law, customary international law is basically everybody will act like a certain thing is legal, even if it's not, and then that actually becomes the law because everybody's acting as such, right? So if Congress were to pass a law and then the executive were to enforce that law for 50 years and Congress doesn't say anything about it, and somebody were to challenge that enforcement, that federal regulation on the merits of it and say, well, that doesn't comply with the statute, then the court would say, well, it probably does, because if it didn't comply with the statute, then Congress probably would have said something. We would see like public debate. We would have seen new legislation. We would have seen something. But it seems like everybody was pretty happy with the enforcement. So this is a meritless case. Even if we might disagree with the letter of the law, blah blah blah, whatever, right? Then quoting Marbury, blah, blah, blah. The court also gave the most respectful consideration to executive branch interpretations simply because the officers concerned were usually able men and masters of the subject who were not unfrequently the draftsmen of the laws they were afterwards called upon to interpret. Ooh, interesting. Okay. That's going to be a law that, or that's going to be an argument that I've seen people make that don't we want the executive branch officials deciding how best to interpret and execute these laws? Like, would we really expect the people in Congress to have the expertise to understand all these things? Isn't this the purpose of the officers and the inferior officers? Isn't it for them to know exactly this? Like, yeah. Destiny chats have to be the most brain dead but legally literate chats on the internet. True. Okay. Respect, though, was just that. The views of the executive branch could inform the judgment of the judiciary, but did not supersede it. Whatever respect an executive branch interpretation was due, a judge certainly would not be bound to adopt the construction given by the head of a department. Otherwise, judicial judgment would not be independent at all. As Justice Story put it, in cases where a court's own judgment differed from that of other high functionaries, the court was not at liberty to surrender or to waive it. The New Deal ushered in a rapid expansion of the administrative process. But as new agencies with new powers proliferated, the court continued to adhere to the traditional understanding that questions of law were for courts to decide, exercising independent judgment. During this period, the court often treated agency determinations of fact as binding on the courts, provided that there was evidence to support the findings. When the legislature itself acts within the broad field of legislative discretion, the court reasoned, its determinations are conclusive. Congress could therefore appoint an agent to act within that sphere of legislative authority and endow the agent with power to make findings of fact which are conclusive, provided the requirements of due process, which are specially applicable to such an agency, are met, and in according a fair hearing and acting upon evidence and not arbitrarily. Okay. When it says Congress could therefore appoint an agent to act within that sphere of legislative authority and endow the agent with power to make findings of factors are conclusive, provided the requirements of due process, which are specifically applicable to such. This would be somebody still working with the legislature. What are they referring to here? Would this be like what in the legislature would we be talking about here? Who are we appointing here? What is that a reference to? I'm going to just read what he's quoting and find out. Where the legislature appoints a rate-fixing agent to act within the limits of legislative authority, it may endow the agent with power to make findings of fact which are conclusive, provided the requirements of due process. In such cases, the judicial inquiry into the facts goes no further than ascertain whether there's evidence to support the findings, and the question of the weight of the evidence in determining issues of fact lies with the legislative agency acting within its statutory authority. Okay. Legislative agency still means agency that exists within the legislature. They're not talking about somebody appointed underneath an executive branch, right? An order of the Secretary of Agriculture fixing stockyard rates not shown to be confiscatory by the evidence before him and against which no further evidence was offered by the company affected in a suit for an injunction held not invalid because the Secretary refused to grant a further hearing on adverse changes in the where the issue is whether rates fixed by the Secretary of Agriculture for stockyard services operate to confiscate property. The company affected, a court is not bound to accept the findings of the Secretary, though supported by substantial evidence, but must weigh the evidence and pass upon the questions of fact. In the fixing of rates, a legislative act, the legislature has a broad discretion which it may exercise directly or through a legislative agency authorized to act in accordance with standards declared by the legislature. Okay. So this would be an agent that exists as part of the legislature. Is there an example of this agent? I'm curious, like what like a legislative agent would be, or like what role or something here. Let me use the restroom real quick. Hold on 1 second. What do you want? I see you're talking to YouTube chat.
Hey,
Hi.
so I was in the comments trying to explain that part of Chevron is initially it wasn't this way, but it came to be that there was a Chevron. What's that? Can you hear me?
Yeah, I'm not saying anything.
Oh, okay. I was saying that there's a Chevron part zero, a Chevron step zero.
Okay.
Sorry, I had the YouTube going in the background, so I was hearing double.
Oh.
And Chevron step zero came as a result of a case called Mead. I forget the full name of the case, but it came as a result of a case called Mead. And so in that case, the long and short of it was that the Supreme Court held that steps 1 and 2 don't even come into effect unless the particular agency has even engaged in rulemaking under the APA, right? Whether that's official or formal rulemaking or informal rulemaking, I can't remember.
Okay.
But that's actually a part of it. And so there's a whole the cases I laid out in the first super chat. I suggested those specifically because they're going to help give you basically the beginning, middle, and end of how Chevron was really constructed, and then how it started to become deconstructed over time. And so if that's sort of your goal, is getting a grip on Chevron itself, I think it's pretty and you've kind of gathered as much. It's pretty straightforward in the sense that it's is the statute ambiguous, and is the agency's interpretation reasonable, right? I mean, that's pretty straightforward. But it's all the other parts of it, and then where the major questions doctrine, I don't know if you've reached that part yet, comes into play, which spelled out the death of Chevron essentially as early as in the early 2000s. But that's sort of the route that I was just suggesting you take to sort of get a full grip on the story of Chevron.
Okay. What part of this court case am I not going to understand by not reading all of those other court cases?
You're reading Chevron right now, correct?
Well, no, I'm reading the overturning of Chevron. I'm reading the decision that came out a couple weeks ago.
Oh, so if you're reading the overturning, it's not that you're not going to understand it. It's that if you're reading it for the purpose of a debate or a discussion about it, this only spells out the symptoms of the problems of Chevron, but it doesn't explain to you the regulatory conception of Chevron, how it came up, and then what the actual departures from the doctrine were over the years that led to this overturning. So you're kind of starting at the end. So it's not that you won't understand it. Obviously, you're going to understand what it's saying. It's just you might need more sort of color in the lines of what the problems actually were ideologically, or not, perhaps doctrinally, that led to this.
I'm sure that Roberts is probably going to talk about some of those, though. No?
He probably does talk about some of those things.
Wait a second. Hold on. Wait. Just checking real quick. Have you read this decision?
Not the entire thing. No, I haven't yet. I'm studying for the bar currently.
How much of this decision have you read? You've read the summary. You've read the syllabus of the decision.
I've read parts of it. I haven't read. I don't know how to quantify.
Sure. I mean, you're saying you've read parts of it, but Roberts did the majority opinion, and if you don't know what's in the majority opinion, which is the first opinion presented besides the syllabus, it seems like you haven't read the majority opinion. So why are you telling me that I need to read other cases to understand any of the construction of Chevron in the background when you don't even know what Roberts has said about it? Maybe Roberts explains literally all of that. It's a 120-page opinion, or 120-page publishing. No.
No, I know. I've read a lot of it, but I haven't. What I'm trying to tell you is that it's not going to explain to you, for example, in Williamson and FDA versus Williamson, it's not going to explain to you the regulatory, the problems in the regulatory scheme. It's not going to color that in for you. And I know that because I have read a considerable amount of it. I haven't read all of it. I'm not hiding the ball on that. But
sure. I'm sure it's probably not going to tell me why the Supreme Court has the authority to even review these decisions, right? Am I expected to read the foundation? If anybody was to read anything, do you trace every single Supreme Court decision back through have you read all of Marbury? I'm sure there's going to be like
No, no,
other
no.
rulings that I'm not like, I won't have the full highlights to why they ruled in Chevron the way they did, but I don't think I have to read every single court case leading up to this. Like here's what I would agree with you for, okay? If somebody were to say we need to have a debate over whether or not this decision was good or bad, then having some background on like, well, what led to Chevron would probably be important, right? Like I'm not going to sit here and have a huge debate on whether or not I agree or disagree with Dobbs without having a thorough understanding of like Casey and Roe v. Wade, right? Like that makes sense. But I'm just like
But
reading.
respectfully, Destiny, what you're missing is that I'm not giving you cases that led up to Chevron. I'm giving you cases that happened subsequently and led up to the overruling of Chevron.
Then
And
then
so
Roberts
I'm giving
should
you-
cite to that if he's making an argument. He's not going to leave that to be assumed. I imagine he's going to have that in his opinion for why he's overruling it, right? That would be what an intelligent, learned man would do. No?
I don't recall, Destiny. And again, I'm not pretending that I've read all of it. I'm also not pretending that you won't understand it. But what I'm trying to say here is that I don't recall I think I read about 30 or 40 pages of it. I don't recall that it was ever explained where the foundation of Chevron began.
Yeah, but you haven't even
Now,
read the whole opinion. So how could you even make that statement?
Because just like how this is a 120-page decision, these other decisions are equally lengthy and substantive. So what I'm trying to say is you might have a different purpose for reading this. I'm not coming at you trying to like criticize you or say you're not. I just gave you 3 or 4 cases, I think 3, that I gave you Skidmore, I gave you Meade, and I gave you Williamson. And I think that these 3 cases, I was just suggesting that you read them as well to help you understand the contours of Chevron.
Okay,
okay,
I got you. Okay, sure. Okay. So then here's the thing. Can you ask me a question? Ask me a question that I would be expected to give like a short essay to, that you don't think I would be able to answer because of my gap in understanding any of these court cases that you're referencing.
You want me to ask you a question that I believe you wouldn't be able to answer without reading the other cases?
Yeah.
Not
like a fact of the case, but like
sure.
like something relating to the overturning of this.
Substantively.
Yeah.
Sure. Give me just a second.
Okay.
I would probably hone in on Williamson, and I would ask you about the major questions doctrine, and sort of the policy reason behind major questions.
Okay. So I haven't done a lot of huge research into major questions, but my understanding is that if an executive agency is trying to make a decision about like a major aspect of like the country or the economy, that this has to be pretty explicitly spelled out by the legislature, I believe, right?
What is when you say this needs to be spelled out? What is the this that you're referring to?
Whatever the federal regulation would be that some office is trying to codify. So if the, let's say the ATF was like, tomorrow we're going to break into the house of like every single person and take all their guns because we've got a new way of interpreting something from the legislature or whatever. Maybe this would be like a major question thing where it's like, well, hold on, if you're going to do something that extensive, we need like explicit legislation from the legislature to do this. This isn't within your power to just have this interpretation and go and do that. Clearly, this needs to be spelled out by the legislature. That'd be my...
Yeah, so you're hitting on a lot of points of it very well, but what you're missing is this. With Chevron, we're dealing with interpretations of ambiguous statutes. With major questions doctrine as a limit to it, it's applicable not just to the interpretations, but to the rulemaking process in general. So it's not even just a limitation on interpretation, but on agency action writ large. So what it's going back to is the enabling acts, these sort of, and you've touched on this several times today already, which you already know what that is. But it's going back to that explicitly, which is, for example, in FDA v. Williamson, it was the regulation of tobacco. And so the actual enabling act of the FDA was pretty old. And in the early 2000s and a little bit before that, the FDA tried to start to regulate nicotine as a drug, even though that's not how drug was construed under the creation of the FDA, right? So like it doesn't have to be necessarily about an interpretation. And that's why it was such a big doctrine, which said it marked more than just a limitation on Chevron. It marked the beginning of the counteroffensive from what I can say respectfully is the conservative side of the judicial branch. The sort of attack on what Chevron evolved to be. And so that is something that kind of helps, again, fill in the contours of what Chevron stands for, because it's not just the interpretations of statutes or interpretation of ambiguous terms. It's actually the entire administrative framework. So that helps color in the lines a little bit.
Okay. I don't think I probably disagree with you. I think if I could, I would download the entire database of Supreme Court opinions into my brain. I don't necessarily disagree.
But you don't have to do that. I emailed you an outline that I created when I took admin law. And I think it has some nice things. You don't have to look at it now, obviously, but if you want, it has some really nice graphics. You can control F and find some different things that explain what Skidmore deference is, or Skidmore respect, and what Mead is, and how all these frameworks work together to start to assemble how administrative law works, and how ultimately it became undone. Because that story is there as well.
Okay. Well, good luck studying for the bar. Yeah.
Thank you.
Have a good one, buddy.
All right, you too.
Okay. I don't think that guy was trying to be an asshole. But now I feel bad because I ended up quizzing him. Okay. Jesus. I don't necessarily disagree with what he said, that no, reading more would help, but I only have so much time the other day. I can't read every single fucking court case. I can't fucking... Okay. We'll continue reading. We'll continue on. During this period, the court... we already read this part, I think. Congress could therefore appoint an agent to act within that sphere of legislative authority and endow the agent with power to make findings of fact which are conclusive, provided the requirements of due process which are specifically applicable to such an agency are met, and in according a fair hearing and acting upon evidence and not arbitrarily. But the court did not extend similar deference to agency resolutions of questions of law. Okay. It instead made clear repeatedly that the interpretation of the meaning of statutes as applied to justiciable controversies was exclusively a judicial function. The court understood, in the words of Justice Brandy, well, that's probably important. We should have. Okay. But I think what they're essentially saying here is that, okay, how would I, if I can't explain this because I don't understand it, half the time when I re-explain stuff, it's just so I'm solidifying the concepts in my head. So if somebody were to challenge something from an executive agency, some federal regulation, where we understand that a regulation is something that an office of the executive is creating, and that source of the regulation should be a statute passed by Congress, okay? That if you want to challenge the way that some regulation is being used or whatever, that the legislature has within it the ability to appoint an agent in the legislature that can do findings of fact for the determinations of whether some fact, I guess, is right or wrong, I guess, for that, whatever the executive agent is talking about. So a fact, what would a fact be? A fact might be like, what is a gun, I guess? Like, what do we consider a gun to be? So I guess, like, theoretically, the legislature, as part of passing some gun regulation, could empower somebody in the legislature to make that determination of fact of this is a gun, right? So this is like a factual thing that they're determining. However, the court did not allow the legislature to appoint somebody to figure out if the executive is adhering to the law, right? So when the legislature, when Congress passes something for the executive, the legislature might still be allowed to do factual analysis to guide the executive, but they can't make a legal analysis. The legal analysis is still exclusively within the judiciary, within the courts. Okay. A fact is a truth in simple terms. No, I wouldn't say that legally, unless your law professor told you, in which case, believe them or me. I think fact, when you talk about law, I think fact is very specifically referring to like a material fact or thing. It's not just something that is true. Well, some material thing. It's not like, for instance, if you were to say, like, the government shall make no laws restricting like the freedom of speech or whatever. Like, that's a fact or whatever. That's not a fact. That would be well, I don't know if that'd be a law. That'd be like constitutional law. But yeah, okay. Okay. The court understood, in the words of Justice Brandeis, that the supremacy of law demands that there shall be opportunity to have some court decide whether an erroneous rule of law was applied. It also continued to note, as it long had, that the informed judgment of the executive branch, especially in the form of an interpretation issued contemporaneously with the enactment of the statute, could be entitled to great weight. So what it's saying there is that, like, let's say an executive branch was saying, thank God Congress is about to pass the Climate Change Act, which is going to allow us to destroy every single fireplace in the United States. And then Congress passes the Climate Change Act to prevent climate change. If somebody wanted to challenge the executive regulation that now made it so federal agents can destroy fireplaces, when the court is tasked with evaluating, well, are they adhering to law here? Is that a good interpretation of what the legislature is saying? One of the things they might look at is like, well, the officer or the inferior officer that was tasked with regulating this thing, they literally said, we're going to blow all the fireplaces up. And the legislature was like agreeing and they passed this law. So it seems to be the case that, yeah, that is right. That's what they're referring to there. Okay. Or at the very least, it would get great weight. There would be like heavy deference. I don't want to say deference. That's not true. There'd be a lot of weight given to what anything in the executive was expressing at the time. Perhaps most notably along those lines, in Skidmore, white bro, the court explained that the interpretations and opinions of the relevant agency made in pursuance of official duty and based upon specialized experience constitute a body of experience and informed judgment to which courts and litigants could properly resort for guidance, even on legal questions. So it's notably in the science. The court explained the interpretation. Okay, interesting. Okay, so matters of law. The weight of such a judgment in a particular case, the court observed, would depend upon the thoroughness evident in its consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all those factors which give it power to persuade, if lacking power to control. On occasion, to be sure, the court applied deferential review upon concluding that a particular statute empowered an agency to decide how a broad statutory term applied to specific facts found by the agency. Remember, every single time we say statute refers to something passed by Congress. So a federal statute, even if it's called a federal statute or whatever, the executive implements statutes with regulations. Okay, the president doesn't pass a statute. The DEA, the ATF, the Department of, none of these things pass statutes. They have regulations, which is a way of codifying or enforcing statutes that come from Congress, right? Applied. Okay. For example, in Gray v. Powell, the court deferred to an administrative conclusion that a coal-burning railroad that had arrangements with several coal mines was not a coal producer under the Bituminous Coal Act of 1937. Congress had specifically granted the agency the authority to make that determination. The court thus reasoned that where, as here, a determination has been left to an administrative body, this delegation will be respected and the administrative conclusion left untouched, so long as the agency's decision constituted a sensible exercise of judgment. Ooh, who has review of that sensible exercise of judgment? Because that would be a matter of fact, right? I wonder who... just for people that watch me take notes, red is really important. Orange is just like a note that's kind of important. Blue will usually be definition. I imagine that a sensible exercise of judgment, that would become under review of the court, I would imagine. The court similarly, in Nlurb v. Hearst Publications, the court deferred to the determination of the National Labor Relations Board that newsboys were employees within the meaning of the National Labor Relations Act. The act had, in the court's judgment, assigned primarily to the board the task of marking a definitive limitation around the term employee. The court accordingly viewed its own role as limited to assessing whether the board's determination had a warrant in the record and a reasonable basis in law. The court accordingly viewed its own role as limited to assessing whether the board's determination had a warrant. Okay. Such deferential review, though, was cabined to fact-bound determinations like those at issue in Gray and Hearst. Neither Gray nor Hearst purported to refashion the longstanding judicial approach to questions of law. In Gray, after deferring to the agency's determination that a particular entity was not a producer of coal, the court went on to discern, based on its own reading of the text, whether another statutory term, other disposal of coal, encompassed a transaction lacking a transfer of title. The court evidently perceived no basis for deference to the agency with respect to that pure legal question. And in Hearst, the court proclaimed that undoubtedly questions of statutory interpretation are for the courts to resolve, giving appropriate weight to the judgment of those whose special duty is to administer the question's statute. So a statutory interpretation is going to mean a legal interpretation, which is not going to be a factual determination, right? The factual determination, when Congress passes a law or creates a statute, Congress will declare who has authority over that factual determination. The legislature either has the ability to appoint an agent to do it, or they can leave deference to the executive to do it. So the court shouldn't be in the business of making a factual determination, but for questions of statutory interpretation, that's for a court to resolve. Okay. At least with respect to questions it regarded as involving statutory interpretation, the court thus did not disturb the traditional rule. It merely thought that a different approach should apply where application of a statutory term was sufficiently intertwined with the agency's fact-finding. It merely thought that a different approach should apply where application of a statutory term was sufficiently intertwined with the agency's fact-finding. Wow, okay. Okay, sure. So I think that the statement there is basically saying, like, let's say that Congress authorized the ATF to ban all guns. So the ATF says, okay, we are banning all guns, but what if the ATF decides to define a gun as like a woman? So they wanted to ban women as well. Well, this could be confusing because now we're intertwining the statutory enforcement. Does the ATF have the ability to ban women? If we're intertwining that with a fact, is a gun a woman? Where the ATF might make a factual determination that also heavily implicates the statutory interpretation as well, I think, right? Oof, okay. And then in that case, it would make sense because maybe the judiciary should have a review of that, even though we might say, well, the judiciary, like the court shouldn't be responsible necessarily for figuring out what a gun is, right? Is it up to the court to determine what type of firearm is or isn't banned? Well, what if we define firearms as being a woman? Well, now maybe the court should have some insight there. Maybe, yeah, okay. In any event, the court was far from consistent in reviewing deferentially even such fact-bound statutory determinations. Often the court simply interpreted and applied the statute before it. See K. Davis, admitted, blah, blah, blah. The quote being, the one statement that can be made with confidence about applicability of the doctrine of Gray v. Powell is that sometimes the Supreme Court applies it and sometimes it does not. Nice. Noting an embarrassingly large number of Supreme Court decisions that do not adhere to the doctrine of Gray v. Powell. In one illustrative example, the court rejected the U.S. Price Administrator's determination that a particular warehouse was a public utility entitled to an exemption from the administrator's general maximum price regulation, despite the striking resemblance of that administrative determination to those that triggered deference in Gray and Hearst. The court declined to accept the administrator's view in deference to administrative construction. The court declined to accept the administrative view in deference to administrative. Okay. The administrator's view, the court explained, had hardly seasoned or broadened into a settled administrative practice and thus did not overweigh the considerations the court had set forth as to the proper construction of the statute. Nothing in the New Deal era or before it thus resembled the deference rule the court would begin applying decades later in all varieties of agency interpretations of statutes. Instead, just 5 years after Gray and 2 after Hearst, Congress codified the opposite rule. Well, it sounds like, so what the lawyer guy was calling in to talk about, it sounds like this is, Roberts is walking through like the different weird regulatory things that the courts are having trouble sorting out, basically. Instead, just 5 years after Gray and 2 after Hearst, Congress codified the opposite rule. Hold on, just to be clear when I say that. Codify, not codify. It's codify, sorry. To be clear, I'm not disagreeing with the caller that came in and said that if you read the entire court case, you'll have more background for understanding the contours. I'm sorry. When he originally typed that in chat, I interpreted that as way more aggressive than it was. Because I think his message was like, Destiny would have a better understanding of this if he read like 3 or 4 other court cases. I was interpreting that as him saying like, I don't know what the fuck I'm reading because of blah, blah, blah. But I understand what he's saying. I'm not, when I said that, I wasn't trying to undermine that guy. I'm just saying that Roberts is walking you through this a little bit. To the chatter's credit, sometimes reading the background can give you a wider foundation to disagree, though, with the judge or with the Supreme Court opinion if you want, or to even understand it better if you want. So, for instance, having a little bit of background on Fitzgerald makes me disagree with Robert's opinion on the prior immunity case a little bit more, because I am aware that Fitzgerald only applies to civil law, or I'm aware that in Fitzgerald, a lot of the justices seemed, especially every dissenter, said that obviously this wouldn't apply to criminal law. We don't foresee it happening, right? Not saying that you should only read prior Supreme Court decisions to either agree or disagree. It can just shape more. It'll give you it'll give you a better understanding of where these things have come from and where they're going. Remember, the thing that I said before is that law is one of those things where when you look at it, it seems like it makes sense. And then when you dig into it a little bit more, it seems like it's fucking nonsense. And then when you dig into it more, it's like, oh, this all exists probably for really, really, really good reasons. And having an extensive background of knowledge and all that helps you get to that point. Everybody say hi to Hamstar. Okay. Congress codified the opposite rule, the traditional understanding that courts must decide all relevant questions of law. Congress in 1946, okay, let's go to now, I guess, okay. Congress in 1946 enacted the APA. Oh, wait, hold on. Footnote 3. The dissent plucks out Gray, Hearst, and to gild the lily in its telling 3 more 1940s decisions. Gild the lily, that is a phrase. Does that mean when you're like trying to falsely dress something up when it's not, you're misrepresenting it? Gild the lily, let me check, hold on. Try to improve what is already beautiful or excellent. Oh. The dissent plucks out Gray and to gild the lily. Oh, but he's quoting it facetiously, I think, right? Three more 1940s decisions claiming that they reflect the relevant historical tradition of judicial review. But it is no substantial response to the fact that Gray and Hearst themselves endorsed, implicitly in one case and explicitly in the next, the traditional rule that questions of statutory interpretation are for the courts to resolve, giving appropriate weight, not outright deference, to the judgment of those whose special duty is to administer the questioned statute. And it fails to recognize the deep roots that this rule has in our nation's judicial tradition to the limited extent it engages with that tradition at all. Oof. Instead, like the government, it strains to equate the respect or weight traditionally afforded to executive branch interpretations with binding deference. That supposed equivalence is a fiction. The dissent's cases establish that a contemporaneous construction shared by not only the courts, but also the departments could be controlling. And then they reference another case. And that courts might lean in favor of a contemporaneous and continued construction of the executive branch as strong evidence of a statute's meaning. They do not establish that executive branch interpretation of ambiguous statutes, no matter how inconsistent, late-breaking, or flawed, always bound the courts. In reality, a judge was never bound to adopt the construction given by the head of a department. We haven't read the dissent yet, obviously, but what Roberts is saying is like, okay, well, the dissent is bringing up the idea that large weight and large deference is given, or no. I keep saying that word, and it is incorrect to say that word. I'm so sorry. It's never deference. Deference, well, at least as Roberts is saying, deference is the wrong word. Deference is never given to an executive head in terms of deciding what a federal regulation should or shouldn't be based on the statute, but a lot of weight might be given, meaning that you would heavily consider what they're saying, right? You're never deferring to them. The court is never giving its deference to an executive head or officer, or under officer, sorry, inferior officer. But it might weigh that decision heavily, right? Okay. Or weigh their input as part of the decision heavily. Congress in 1946 enacted the APA as a check upon administrators whose zeal might otherwise have carried them to excess not contemplated in legislation creating their offices. It was the culmination of a comprehensive rethinking of the place of administrative agencies in a regime of separate and divided powers. In 1946. In addition to prescribing procedures for agency action, the APA delineates the basic contours of judicial review of such action. As relevant here, Section 706 directs that, to the extent necessary to decision, and when presented, the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. It further requires courts to hold unlawful and set aside agency action, findings, and conclusions found to be ... not in accordance with law. So I don't know if I would say this is necessary or not. I mean, it was passed, but as it should be, it reaffirms basically the court's sole jurisdiction order over matters of law or statutory things. The APA thus codifies for agency cases the unremarkable yet elemental proposition reflected by judicial practice dating back to Marbury. Oh, okay, so Robert's saying the thing. We're like, yeah, that courts decide legal questions by applying their own judgment. It specifies that courts, not agencies, will decide all relevant questions of law arising on review of agency action, even those involving ambiguous laws, and set aside any such action inconsistent with the law as they interpret it. And it prescribes no deferential standard for courts to employ in answering those legal questions. That omission is telling because Section 706 does mandate that judicial review of agency policy making and fact-finding be deferential. Agency action to be set aside if arbitrary, capricious, or an abuse of discretion. Agency fact-finding and formal proceedings to be set aside if unsupported by substantial evidence. Okay. Which makes sense because policy making is creating a regulation from a statute. And fact-finding is just like finding a fact, right? Courts aren't supposed to, the Supreme Court is supposed to do fact-finding, or they're not supposed to figure out if a regulation accurately is like, if a regulation is like, how would you say this? Is effective or ineffective at carrying out like a particular statute? They're just supposed to see if it's like if it's a good legal interpretation. It's only statutory interpretation and adherence to the law, basically. Has your voice gotten used to reading so much on stream? You seem less worse than before. I think I was sick before. I'm still a little bit, but I'm almost over it. In a statute designed to serve as the fundamental character of the administrative state, this is a 2019 opinion, plurality opinion. What does plurality opinion mean? Internal quotation marks omitted. Congress surely would have articulated a similarly deferential standard applicable to questions of law had it intended to depart from the settled pre-APA understanding that deciding such questions was exclusively a judicial function. Oh, plurality, because there wasn't, because they didn't have the Supreme Court justice then? It was still 8 members? Or, wait, not majority, but the winning opinion. Wait, can you have Supreme Court people that don't, like, vote? Or don't, like, thumbs up or thumbs down a decision? Like, could you have, like, 4 that would, like, affirm, and, like, 3 that would dissent, and then 2 that were, like, fuck this? They can abstain? Oh, interesting. Or they can recuse. Oh, okay.
Hey, dude.
Hi, what's up?
Wondering if you had time to chat a little bit about the Biden debate.
Yeah, fuck it. We can chat for a little bit about it. What about it?
Yeah. So, from my perspective, I think the big issue that people have with the debate is Biden clearly is older. I don't think there's any debate that he has age-related cognitive decline, but people are confusing that with Alzheimer's dementia. Based on what I've seen in the debate, and just the way you can see like Trump acting at his rallies and crap like that, Trump has much more clear signs of dementia than Biden. It's just that other age-related symptoms of cognitive decline, they're not as apparent in Trump. And some of that might be
I don't know if I would say... I don't think Trump has displayed any signs or symptoms of like dementia or anything, no?
No, he absolutely has. David Pakman's done some really good videos on this, and he's gotten some psychologists and psychiatrists and neurologists to talk about this. Trump will do things where he will be asked a question, he will say something that's vaguely related, and he will then trail off into a completely unrelated topic and then say, like, just weird, baffling things, like about how magnets don't work underwater.
Yeah, but like this is how Trump has like always talked, right?
No, not always. I don't know of any, like, so one issue, you could maybe say that, but I can't find any examples of him, like, back in the 80s or 90s, where he would just say weird, absurd shit, where he trails off into completely unrelated subjects, and then says things that are not interconnected, don't make any sense. Like, that's a sign of dementia, where somebody will be talking about something and then randomly bring up, like, how magnets don't work underwater. Another thing that Trump does is he will, like, literally mix up people. So, there was one point at one of his rallies where he literally thought he was
thanks for the 20
running
bucks,
against
Justin.
Barack Obama.
Did he literally think that, or did he just like misspeak or mix something up in his head?
It sounded like he literally thought that. Here's the thing. If you have age-related cognitive decline, you tend not to mix up people. You will mix up names or forget somebody's name. So when Biden's talking, he'll say, "Yeah, Karen. Oh, I mean Sharon. Like, he'll say that if he's, talking about somebody. He'll just forget their name. Trump will often confuse people for other people. I think he's confused his actual children for other people. He's gotten confused who his wife is. He's gotten confused about who he's running against. So, like this is a repeated pattern I've seen. Like, what I see from Joe Biden is he'll forget, or he'll be a little slow, and he might stumble over his words a little bit, but then he'll, like, remember, this is the name, or this is the number that I was thinking. Trump will have, like, a completely different symptom. It's not age-related cognitive decline. It's like a delusion, where he will think it's a completely different year, or he's talking about a completely different person, and he'll have this confused delusion.
Okay, I think you could make that argument, but I don't think that any of this would be convincing to the average voter. But
Right. Well, I'm saying, like, that's the issue. People are kind of confusing age-related cognitive decline with dementia. You can have age-related cognitive decline and be completely competent. I think Biden did much better in the debate compared to Trump.
well, when you say did better in the debate, do you just mean that he? I mean, like, that's begging the question of, well, what do you mean by better, right? Because some people say better just means sounds better rather than like displays facts or whatever,
yeah,
right?
So if we look at how the debate went, they were talking about things like relations with Russia, Ukraine. They were talking about economic policies, national debt, stuff like that. Biden would make relevant, cogent answers that made sense and that largely stuck to objective facts. He made a few missteps. I think he wrongfully... I think at one point when he was talking about medication costs, the number was like 2,000, but he said 200. But Trump, on the other hand, he would literally just talk about immigrants, no matter what it was. He just... any question, he would just bring up immigrants. So, like, if we're judging, like, who did better in the debate, like, yeah, Biden was an old man. He was a little slow. He did stumble over his words a little bit here and there. But if we were to just look at a transcript and remove all that, Biden was giving good, cogent, relevant answers to questions he was being asked, where Trump had a complete inability to do that. He would be asked about things like the national debt. He would just talk about immigrants. He would have to be asked 2 or 3 times to answer the question, and then he still wouldn't answer the question. Then finally, he'd get back to the topic, and then he would just make up fucking stupid bullshit. Like he would say, "Oh, well, the economy did much better under me. I had the national debt under control." When that wasn't true, he was like he spent more on like he inflated the national debt more than any fucking president in a 4-year term, and that's even pre-COVID. His pre-COVID national debt spending was way above Biden throughout his entire term. They were also discussing the environment. Trump said, "Oh, I was talking to my top environmental officials. We had H2O. We had the cleanest water." And then, like again, that's another example of his delusional thinking. Like, we had H2O.
Okay, I'm not going to
the
disagree
fuck
on
does that-
anything that you're saying.
Yeah.
Like, I understand what you're saying. It's just not going to be convincing to the average person. But I mean, I understand what you're saying.
Right, but I mean, okay, so this is another problem. I'm seeing this in left-wing media where rather than trying to do a good job, trying to convince the public that Biden actually did have a good debate performance, we can admit, yeah, Biden's an old guy. He has health issues related to old age. He could die at any moment. Like, he's at that age where, yeah, he could just die of a stroke. As far as his cognitive capability is concerned with being a president, he's clearly cognitively capable. And especially if we're looking at the two options, he's obviously more cognitively capable than Trump. That's not the narrative you're hearing from the left. Like, especially on Young Turks, they're like, "Oh my God, this is disastrous. We need another candidate. Biden is completely incapable of being president." And they're ignoring like what he actually said during the debate and his actual cognitive capabilities. I think this is a huge problem with the left, where you'll see right-wing media. They'll actually defend the candidate they want to promote. They'll say, "Oh, well, when Trump makes like a stupid, crazy, delusional ramble, they'll just say, 'Oh, well, it was a joke. Oh, his teleprompter malfunctioned. Oh, that's just Trump being funny.'" Whereas when you see Biden maybe make a slight misstep, "Oh my God, we need a new candidate. This is disastrous." I think I think the right-wing media and even like the PR teams for right-wing politicians, they do a way better job of promoting their candidates.
Yeah, it's possible. The reality is that the Conservative Party plays by like a totally different set of rules and standards right now. So
Yeah.
I don't know how to counter that. That's a really challenging thing. Yeah.
Well, like again, this is an issue that the left has. They have this idea that, politicians need to be tactful, they need to be respectful, they need to play by this like chivalry kind of rule. It's one thing that you can say about Trump is it's nice seeing a leader who has these sort of like who's just kind of down to earth. Like, when like when Trump was asked about Kim Jong-un and North Korea being a nuclear threat, like, what do you think about North Korea having like nuclear missiles? Trump would say, "Oh, well, why don't you tell little rocket man that my button's bigger than his?" Like, I don't know why Trump, after that Supreme Court ruling, said like, "Oh, this is like terrible for the country. We need a rule of law." I don't know why he wouldn't have taken the opportunity to say, "Well, now that it's illegal, I guess I'll call SEAL Team 6 to assassinate Trump." We kind of need more of that from the left wing, and I think they're kind of shooting themselves in the foot by playing this game where they can't like sling mud, they can't be kind of real, say what they think, and say some things that are kind of a little spicy.
Okay.
Yeah, what do you think of that?
I actually agree with you a lot more than probably anyone in my audience thinks. It's just an unwinnable conversation because most people just don't see it. Most people don't know what cognitive decline looks like. Most people don't know what dementia looks like. If I were to put my mom up against either of those two candidates, I think my mom would look just like she would eviscerate them because of how good she is at just like arguing and getting her thoughts out and everything. And I think my mom is I think 5 or 6 years into having Alzheimer's disease. But you wouldn't even be able to tell. Most of my chat couldn't even tell when my mom was chatting with me a few months ago on my stream, except like after like 20 minutes, sometimes she would ask the same question again. And then some people were like, oh,
Right,
wait, is that?
yeah.
But Trump can just do this as like it's part of his campaigning when he repeats the same shit over and over again, because the guy only has like 4 lines that he repeats. So yeah, most people just don't know what cognitive decline looks like. Legitimately, if you look at Biden, like he looks like a dude that's like aging and getting old, and maybe his mind is getting a bit old. But in terms of like cognitively, can he perform like the functions you expect to? Yeah, I would think so. Like if it came down to, in order to survive as a country, there's going to be like an Olympic level, fucking 5-minute time allotted to both sides debate between our leaders and other leaders, then at that point I might say, fuck, okay, Biden can't do this. He can't win a debate against Putin, with time limits or whatever. But in terms of like cognitively, who can run the country, I don't feel like we've hit a point yet where either person has hit a stage where it's like, oh God, I don't know, cognitively, this guy's like all there. People just base that on how they hear somebody speak and talk. But I mean, like it is what it is. I would never take that argument publicly because nobody's going to hear that. Yeah.
Yeah, so I think that's what left-wing media really has to do, and they have to kind of get more informed themselves and kind of like...
Yeah, it's just hard because I don't know
yeah.
why it works out this way, but the right is able to dictate the rules that everybody plays by. Like, could you imagine, for instance, if Biden's campaign, or if people around Biden were to say, okay, well, hold on, guys, like we can't, like, let's just kind of like focus on the concepts of what he's saying and don't like listen to the words themselves. Like the amount of cope that people would screech at you from the conservative side would be unending. But on the conservative side, like they could say things like, oh, you're not supposed to take Trump literally, just take him seriously. And like everybody just like, oh yeah, sure. Like that's it. That's just like, oh, okay. Like everybody just accepts that. It's like, wait, how we can't take the president of the United States literally? What is he, fucking retarded? He can't speak well? But for some reason, I don't know why, the Republicans are able to play with such a devolved rule set, but then still try to come up to the liberal rule set when it's time to evaluate the candidates. I don't know. I don't know why that is the case. I'm not sure.
Yeah, I think what the conservatives do is they kind of pressure Democrats and liberals into kind of proving themselves. Like for some reason, I think when you kind of have this debate where it's like, oh well, like prove to me, what Trump said is stupid. Prove to me, like what Biden is saying is like Biden's cognitively capable. Democrats kind of immediately jump on that and they try to like defend their party member. And I think that's why they're like when you have a political side that's kind of asking the question and asking for the burden of proof, I think that's kind of how they're dictating like the political discourse. You don't really see much of that from the left. Like the left is it's kind of more insulated in a way where they're not really as interested in having these discussions with Republicans, with right wingers, where they kind of ask for these people to prove, okay, well, why is your candidate better? Why is Trump cognitively capable? And I think that's how that kind of works out, where we're always the ones on the defense, kind of saying, oh well, Biden's good. Let me explain why. And I think there's also a cult of personality thing here too, where no matter what, they're just gonna defend Trump.
Sure. Okay, what do you want? Forethought.
Hello?
Hello.
Sorry, I had push to talk on. So the big thing is that between Trump and Biden, the entire Republican Party, their voter base, it's not a media thing. The media is hostage to the voter base of the Republican Party. That's not the case for the left wing. The Republicans overwhelmingly support Trump. That's why all of his scandals, all of his crimes, basically anything he does is excused by them, and we can't do the same thing on our side. Biden just does not have that support, and it is overwhelmingly the case that a vote for Biden is not considered a vote for Biden himself, but against Trump. I believe that's like 60-something% of the electorate at the moment. And in terms of Biden as a candidate, the media doesn't dictate this election. The idea that like the media can just wallpaper over Biden having a senior moment on a 50 million viewer debate is just, I don't know if like
They can't
if
wallpaper over it, but there's definitely like both sides can play into each other. Like they can't wallpaper over it, but does there need to be 400 fucking articles on it? Probably not.
it depends. So I guess first
I'm curious. Here's a quick question on that. Like if I were to, I don't know if there's any way to Google this, but if I were to see, were there more news articles written about the last Supreme Court decision or about Biden's debate performance? What would you think?
Probably Biden's debate performance, absolutely, and I would expect that the voters can dictate who the president is. They can't dictate a Supreme Court decision. But I guess.
Wait, what does that have to do with what the voters can? The voters can't dictate anything happening between Israel and Palestine. We're not.
That's true. Yeah.
So I mean, like I don't know what, but okay.
But I guess my question for you is, do you have any reservations about Biden's mental faculty?
I mean, I think he. What do you mean by that? When you say mental faculty?
As in, do you think there is any way he is limited by his age or mental capacity in terms?
Yeah,
of
no, I understand. But limited, limited how? Sorry,
yeah,
I think you're saying.
As in terms of limiting his ability to perform the functions of the president or be able to campaign in this election?
I would say no.
It's hard. The thing is, it's hard to understand. Like, well, let's say that, like, if I say yes, like, if he was functioning better, what are some alternatives that he would be doing besides like doing a better job in a debate? It's hard to say that. I don't know. Like, I mean, I would imagine him being younger would only be better. I know, at least in terms of him, like, speaking, it seems pretty obvious that he was a much better and much more passionate speaker when he was younger. But in terms of, like, running his campaign, I don't even know how much input, like, a individual has into running their campaign. So it's hard for me to say.
Well, I guess to follow up on that, the other half of that is, how much have we seen of Biden that we can be confident in our assessment of his mental capacity? And how much does the average voter know about his mental capacity? Because my understanding is Biden has been very inaccessible in terms of being able in public interviews and in like unscripted events. He's just much more private as a president. And I think that there is a shock amongst the public seeing that debate as like probably the largest public viewing of Joe Biden in a very long time.
Maybe, but I mean, like, he did the Howard Stern thing and everything too. I think the debate for this wasn't a shock because it was the first time the public saw him. I think legitimately he looked way worse in this debate than he has in any other public appearance that he's been in at all.
Yeah, according to the tracker that Ipsos does for all the debates going back to 72, it was the worst debate of all time.
Sure. But I mean, like, keep in mind that, like, there's other stuff that goes into this as well, which, like, it looked bad for sure. But if you actually like look at if you were to do a factual analysis, so for instance, neither side was allowed any notes for the debate and no teleprompting for the debate, right? I'm trying to legitimately remember. I don't know if Trump, this must be a hyperbole to say this. Did Trump bring up like a single fact or figure at all?
No.
I don't think so. But
I don't know
think it's
and like Biden is trying to rattle off like 500 fucking things. One of my criticisms was that like I think that his debate approach, ignoring age and everything else, was just bad. He should have focused way more on like slogans and shit. But so like if we're thinking in terms of like mental capacity or like cognitive decline, like if Biden would have gone on stage and if he would have just did like quips or one-liners the entire time, even though in my opinion that wouldn't showcase higher mental functioning, the impression would be that it is. So when you ask me, like, do I feel like mentally he's declined to the point where he can't run the country? I don't think he's declined to the point where he can't run the country. It could be that he's declined from like where he was before, for sure. I don't think that it's at a point where like we're getting nuked and he's like drooling at the Oval Office desk and we're like fucked.
That question isn't like is he like mentally fucked? It's just that if you have reservations about his mental faculty and you've been very plugged in, the average voter is not plugged in at all, and that's probably the most they've seen of Biden in a long time. And that debate was not a referendum on his ability to recite facts. It was a referendum on his age. If he had spoken on principle, on anything, and just appeared normal, he would have crushed the perception that Republicans have been setting up for years at this point, that he was too old.
Sure. But I think he theoretically could do this at a future debate, right?
Yeah, but and by the way, like I mean, I think the media was being incredibly uncharitable. Like they were talking about how his mouth was open, he was like smiling.
His facial
in a weird
expressions
way.
are really dumb.
Well, like I mean, Trump was saying the most insane shit. Like at one point he was saying Biden's going to raise your taxes by 4 times.
Yeah.
Meaning like people in the middle income bracket are going to be paying 100% tax. Like,
Everyone knows
yeah, no
Biden's
shit.
insane.
Biden's
Yeah.
going to open his mouth and smile and be like, what the fuck is this shit? But people are saying, oh, he's delusional. He's thinking about cotton candy in his head. And he's just like smiling for no reason. Like, these reactions were reasonable reactions that anyone would have listening to somebody say stupid, insane crap.
Maybe, but the average voter disagrees. It's just
Well, your average voter is a fucking moron, too.
Okay,
Yeah, but
well,
your
they-
average voter is
they
your voter
decide the
who's voting in
election.
the election. Yeah.
Yeah.
I mean,
Yeah, but I mean...
Okay,
like,
real quick, I'll give each of you one more
again,
sentence, and then I gotta go because I'm doing this debate now. So
Sure. Like, I don't know why the left-wing media is giving the most uncharitable, take on this. Like, the Biden facial expression thing. I don't know why they're not just saying, like, yeah, Biden's going to, like, kind of smile and smirk and have this, like, gasped face when he's against a debate opponent that's just saying insane rambling shit. Instead, they're giving this narrative that, oh, this guy is like thinking of cotton candy and he's in like delusional la la land.
sure, it's the different rules
When
for both
I
sides.
don't know
like
why you would-
There's like even on the facial expression things, like when Trump's facial expressions are wild, it just becomes a meme. Do you remember the meme
Yeah.
of like the Trump short circuiting?
yeah,
Yeah.
the spazzing out.
Yeah, like if Biden were to do this, people would assume that like wait, fuck, can I find this?
Yeah, his voters support him. That's
Yeah,
the
people would
easiest
assume that like Biden has lost his mind if he were like doing shit like this. But for some reason, when Trump does it, it's like funny. Yeah.
Yeah,
Alright,
and I can't stand it. I don't know why the left-wing media does this. Even if you don't particularly like the guy because you think he's Genocide Joe, like, I mean, again, the idea that Trump would be better at, handling the Israel-Palestine situation and he wouldn't have pressured Israel to, like, stop using 2,000-pound bombs, like, the likelihood of Israel using nukes in Gaza under a Trump presidency is far more likely compared to a Biden presidency. So I don't know why the left wing can't just like have at least a little bit of charitable support for the better candidate.
All right, I'll just leave my last bit and then I'll go. You can tell me which part of this is like mental gymnastics or not accurate. The elections are decided by voters, not news media. 72% of the voters think Biden is too old to hold office. That was reinforced by a 50 million viewer debate where he looked incredibly old and was not entirely coherent. People don't want to vote for someone they think is unfit for office. Biden currently has no electoral advantage. Biden's currently polling behind his VP. Michelle Obama polls 11 points ahead of Trump without a campaign, without an endorsement. People are not loyal to Biden. 63% of them vote against Trump, not for Biden. And we should replace Biden, even if it's really, really difficult.
I think replacing Biden at this point would just be a guaranteed Trump victory. I just don't see how you could replace a candidate this late in the game and actually expect to get a victory.
All right, well, the polls disagree, so good luck.
Yeah, and by the way, most people didn't even watch that debate. What they're doing is they're watching like little clips and snippets of the debate. And again, the left-wing media providing these little, snippets and then giving the most uncharitable, kind of view on this. It's only like, again, promoting this idea that Biden's cognitively unfit when what they could do is just stop being fucking morons, stop being uncharitable to the better candidate, and they can kind of promote a more like truthful, nuanced narrative that paints Biden in a fair light, but they're not doing that for whatever reason.
I've said my piece on this. Anything else?
No, not really.
All right, peace out.
All right. Be sure to feed your cats a vegan diet. Peace out.